All right. So, I guess this is our first episode, which is going to be very not formal, but we're going to talk about sort of interesting case that we had this week, right? Hopefully we'll do this weekly, very, informative, sort of giving them a little bit, giving our sort of clients a little bit more knowledge and what's happened, in our firm setting. So, I guess this week we had an interesting case with one of our clients, right? So, can you give
We
me
did.
a little bit of background about that? What happened?
Sure. So we represent an organization that has various homes with vulnerable sector as their patients or residents, and they recently were served with a statement of claim, which means they were sued by one of their employees because one of these residents or patients um, not meaning any harm, but because they were dealing with certain special needs that uh, didn't allow them to control all their actions as well as they would like, accidentally struck one of the employees in the face and caused some significant damage.
Right.
As it turned out, this employee had recently been involved in a serious accident outside of the workplace,
Mhm.
but that had left her in the hospital for 3 or 4 months. So she did some significant um, recovery and rehabilitation to be able to come back to work. And the truth is, the workplace, our client didn't even know about these injuries.
Okay.
But that being said, this employee got significantly injured
Mhm.
and looked to sue our client, the owner of the home, for significant amount of money.
Now, just putting on my personal injury law hat, a lawyer hat, were they suing as an occupier's liability sort of type, saying that you should have, like, I was injured at work? Because there's WSIB, right? I don't know if that's something that they look into.
So this particular client did not have WSIB
I
for,
see.
and that's obviously an employer's decision whether to go to take on that expense or to kind of roll the dice. But so they did look at occupier's liability as well as other issues such as vicarious liability, such
Hmm.
as negligence, such as a bunch of different causes of action as to why the employer should be responsible for these damages, even though everybody knew that what type of patients we were dealing with, and
Hmm.
everybody knew the inherent risks associated with that, as
Hmm.
well. Which one of the allegations in the claim was that our client was negligent in not providing ample training and courses how to deal with
Right,
patients.
right.
But the truth is, our client actually does have ample training. But what makes this case interesting is very, very early on in our research, we were also provided by an opinion letter by the insurer, so our client's insurer,
Right.
uh, denying coverage for liability for this type of claim.
Yeah, because that's what I was gonna get at. Well, then, say, employer gets sued, there's a liability insurance, right? So I was gonna get at that. What wouldn't the liability insurance cover these sort of things, right? And then you just answer the question that they denied it, right?
Exactly. So now, what is very common when dealing with vulnerable sectors, or I guess any type of employers where there's inherent risks or dangers, is they want to keep a good relationship with their
Hmm.
insurance brokers, because sometimes getting coverage isn't easy.
Hmm.
Like for example, I know schools have a hard time getting group insurance because
Right.
you
So
know
many incidents could happen, right? Yeah.
exactly what has happened, or like if the teachers have families and they make a lot of claims and they might not renew the coverage. So it's our clients gave us two very specific instructions. One, see if we can kind of address that denial of coverage, but two, do everything to jeopardize the relationship with the insurance in general, because you don't want to cut the nose to spite the face. They want to make sure that they had insurance, and they didn't want this to cause friction and perhaps cause a lapse of coverage or a denial of coverage when it came time to renew the policy.
Right, right. So I guess at this point, so we were our clients sued, or were we just served with the notice letter?
No, we were actually sued with a statement of claim.
Right. Okay.
Now, the lawyer on the other side specializes in these type of claims.
Mm-hmm.
So I reached out to her and I explained that we just got retained. We're
Mm-hmm.
just in preliminary stages of doing our research, and I also advised her that we're going to be reaching out to the insurance to get some clarification with respect to coverage. And
Right.
interesting enough, she was actually already contacted by, I believe, by the insurer, which is confusing a little bit, but the insurer had told, I think she called the insurance company, and the insurance had already advised her that they're not covering. So,
Mm-hmm. Mm-hmm.
so she already had that conversation with insurance, but she definitely gave us time and indulgence, which is very common. Lawyers give other lawyers indulgences all the time
Right. Right.
because litigation takes many, many, many years to fruition. So an extra
Right.
year, a month there isn't really a big deal.
Mm-hmm.
So the lawyer was nice enough to give us that month, and then we started turning our mind to say, 1 second, our client believed that they were insured for this type of scenario.
Right.
What authority did the insurance company have for denying coverage?
Right. So I guess this became the, worst nightmare for anybody that insurance is denied and you're on the hook for the whole thing. They probably sue for 1 million or 2 million boilerplate, whatever that was, personal injury, which we normally do a lot. So I guess what happened? So I mean, I guess moral of story is we somehow saved our client. That's why we're
Yeah,
talking about this,
but
right?
spoiler alert. Right, first,
Oh, okay, sure. Thank you. Right, yeah. So, I
let's
mean,
break it up.
this story would not make into this episode unless we did something, right?
That's true. So, what made this interesting is that we took a closer look at the policy.
Right.
And in the denial letter, and this is a cautionary tale, the denial letter gave a couple of provisions in the policy that they were relying on for denying coverage.
Mm-hmm.
But it's important for the insured or their lawyer to take a look not just at those two paragraphs, but to see the forest for all the trees, and to take a look at all the paragraphs and the entire policy. And it's
Mm-hmm.
all boring jargon. It's definitely not a page turner, but you
Yep.
got to work your way through it to see if they either intentionally, but let's give the benefit of the doubt, unintentionally, um, didn't notice another provision that may have spoken to coverage.
Okay.
And we to help, we have a great team here, and we one of our staff, one of our, I think it was an articling student, was able to pull up the policy, and she found a provision in the policy
Mm-hmm.
which could very well have been argued would have meant that this very specific case where an employee that got injured during work was covered by the policy. It was very, very, it could very well be argued that there should have been covered extended.
So you're saying that there was some ambiguity or contradiction within that policy, right? So one section could very well say no, but another section said maybe, right? Is that what it was?
To an extent, basically, the policy spoke about a Canadian resident employee.
Mm-hmm.
And the plaintiff, the person suing this case, was a Canadian resident and she was an employee. So,
Mm-hmm.
in theory, that there should be coverage because the policy said that type of worker gets covered. But
Mm-hmm.
what the insurance company were saying is no, that term is referring to a very specific type of employee, a domestic, a cleaning service, housekeeping, janitorial, things
Right.
of that nature. So they were relying on an interpretation or a definition that might not be the first one a layman such as myself, who's not an insurance expert, would understand that term to be.
Mm-hmm. So, and then we I guess we found a contradiction or ambiguity in the policy, and we went back to the insurance company and somehow convinced them to cover our clients. Like that's what happened. But
Because typically, sorry to interrupt, but typically, if there are terms that are specific to this policy, there's a section of defined terms in every policy.
right, right,
If if a person creating a contract is
right.
relying on a specific interpretation of an otherwise ambiguous term,
Hmm.
that needs to be specified in the policy. And the fact was, this Canadian resident worker was not defined anywhere in the policy,
Right.
which, which can lead the reader to be unsure
Hmm.
of what this means. So we have one provision that says no coverage, but then we have one provision that says this Canadian resident worker is covered,
Hmm.
but doesn't really tell us what that Canadian resident worker is. So the insurance policy, the insurance company at first were taking the position, nope, that means domestic cleaning and therefore no coverage.
Hmm.
And it was us that was able to, gently nudge them by asking them to point us to either the definition section that would explain their interpretation of that term,
Hmm.
or under what authority they were relying on that the ambiguity can be read in favor of the insurance policy as an insurer as opposed to the insured. And
Right.
we did some research as well. And there's Supreme Court of Canada, which is the highest court in the land. They made it very clear that when there's ambiguity in insurance policies, that there's term of contra ferendum, which means where there's ambiguity, you look to the benefit of the doubt is given to the non-drafter, which means the party that did not write the contract,
Right.
they're the one to get the benefit of the doubt. And the insurance company, the creator of this policy,
Hmm.
unfortunately or fortunately in our case, they're the ones that have to deal with the fallout of any ambiguity.
Right. So I was gonna use that word contra preferendum. It was,
Right.
dropped a big word, but you
I
stole my
know.
word. So thank
We
you.
and I
Thank
always
you.
talk Latin to each other, so I'm
Yeah,
sorry.
I know. So we do that all the time, right? So we
Yeah,
spoke to
yeah.
each other Hebrew in the past, or ancient Greek. So I mean, that's
And
fine.
I'm learning Korean. It's fantastic.
Right, right. So the big question, right? A lot of people would ask, okay, so we hired you as a lawyer, we did this, insurance could cover it. How about the time from the, I guess when insurance said we're not going to cover you, but then they have to pay the legal fee out of their pocket, right? Until they win the case or at certain point. So who pays for the legal fee at this in this case?
Excellent question. And we've got we during our conversation with this insurance adjuster who specializes in this area, we were able to convince them that the fees spent both on researching the actual claim, because we divided our resources. We spend half the time assuming that we're going to have to defend this claim, so we started looking into occupier's liability, negligence, standard of care, duty of care, all that
Hmm.
was in the standard. If there was involved here. So that we spend resources and time and billables at that end. At the same time, we spend time researching this insurance denial. And both, lawyers, we sell time.
Yeah,
That's what our trade is. That's what our wares are. And we spent quite a bit of time on both areas. And the insurance company agreed that they would be covering the legal fees spent from the date of denial to the date of the reversal. And unfortunate for the insurance company in this one is that the adjuster actually was on break, on vacation for a couple of days. So those 2 days that he wasn't back and notified us about the reversal, we actually spent quite a bit of hours on the file. So that's going to end up costing the insurance company, some extra money as well. And our
right,
client is thrilled because that money is not coming out of his pocket. That's coming out of the
right.
insurance.
So at the end of the day, he had a worst nightmare ever, being sued, insurance not covered. He was supposed to pay out of his pocket, but then we were able to turn it around that his legal fees covered. His now insurance is covering the damages, so everything was made whole at the end, right? Sort of thing.
Exactly. And what the insurance company is doing is subrogation, which means they are taking over the defense of their file.
Right,
So sometimes
right,
insurance companies will either use their in-house counsel, lawyers that are full-time employees of insurance
right.
companies,
Yeah,
or sometimes they'll farm them out to external counsel. And we offer them if they want to hire us to represent the client. We're happy to do that as well. But the only difference is we'll be submitting our bills to the insurance company, not to our client. So we haven't heard back on that one, but that's always an option that can happen in these type of scenarios.
Yeah, so it's exciting story that during the COVID you're at the office, I'm at in my basement right here, and then I think half of our team somewhere else, right? Everyone's just kind of working. Amazing. We're actually welcome to 21st century, law firm 2.0. But great, thanks for sharing this. I guess that's what we do. As a Vaturi Cho LLP, it's a full service boutique, right? We do insurance defense. We do a lot of personal injury, real estate, corporate, commercial litigations. Employment law that you do,
Hey, those in the
um,
States.
wills in estate, family, criminal. So it's funny that when we list it, it's like it's a crazy amount of stuff. But then, at the end of the day, it goes back to the principle, right? Like attention to detail, and try to find the case law, and everything catered to the facts scenario. We try to find a solution, right? So that's what we do. They bring us a problem, we find a solution for them, right? Right.
100%.
So, well, thanks a lot. I mean, this episode became really formal. I was hoping just kind of like joke around, but I guess it had to be because the content of it. It had to be a little bit more formal. I'm okay with that. It's like as our first episode.
Next time I wear a funny hat.
Yeah, like maybe we'll do like sunglasses and do
Yeah,
something.
keep
Well,
it
thanks
classy.
for your time, Avi. Hopefully we'll do more of these. Like every week, one case. And then talk about case that we have. And I think this was very informative. So if you are interested, we have a lot of YouTube videos. Subscribe and like button definitely helps us. You can find us on Facebook. Could definitely find me and Avi on LinkedIn. Also, those Korean people, we have something called Kakao Talk. You can, access us. We don't have a Twitter. We don't have Instagram yet. We're not that fancy, but we'll get there, sooner or later. But, if you
We need to work on
feel
our
free,
TikTok, right?
sorry?
We need to work on our dance moves for TikTok.
That's correct. So TikTok, we're gonna figure something out on that one. But if you need some kind of question, something to discuss us, definitely call our office. Description below you'll have contact information. Also, leave a comment below on our Facebook or here. Then we'll definitely see if we could address that in the future episodes. Right? We haven't even decided what this is gonna call. This is the first ever episode. Yeah, I mean, I'm thinking about. I don't know. We will decide. Maybe you could leave us comment as to what we can call this as well. I don't know who's gonna watch this, but I mean, we'll see.
Right?
Maybe our families, maybe your children, my children will watch it and say laugh at us. Yeah.
All
All right,
right.
cool.
Sounds
Thanks for
good.
your time. All right. Okay,
Thanks so
bye.
much. Take care.